To start a court case against a tenant for non-payment of rent, landlord needs two documents, a petition and notice of petition. A petition is a document which is usually prepared by the landlord's lawyer, and petition contains factual information about the case, about the landlord, about the tenant, how much rent is owed, and so on. A notice of petition is a standard two-page form that basically needs to be filled in. In the next slides, I refer to petition and notice of petition together as P and NP. So once the petition and the notice of petition are ready, they must be filed with the court, and the court will assign an index number to the case. Index number, that's a unique number which is specific to that particular court case between a particular landlord and the particular tenant. And only after the index number has been assigned, a paper copy of the petition and the notice of petition must be served upon the tenant. By served, I mean delivered. As I mentioned in the previous slide, there are a whole set of rules how the legal papers should be served, and the full explanation of those rules, how the legal papers are to be served, are on my website. I also would like to mention here that in my experience in Brooklyn, sometimes it took around 4 weeks for the court to issue an index number. So, as I said, landlord must wait till the index number is issued in order to get the petition, a copy of petition and notice of petition delivered to the tenant. So sometimes that waiting period in Brooklyn was around 4 weeks. After the petition and the notice of petition were delivered to the tenant, the law gives to tenant 10 days to come to court and file an answer. And answer is a legal document signed by the tenant that explains the reasons why a tenant is not paying rent on time. Those reasons are called defenses, tenant's defenses. So from this rule, there are two possible scenarios. Either after the petition and notice of petition were delivered to the tenant, tenant comes to court and files his or her answer, or tenant basically can simply ignore the petition and notice of petition and basically do nothing. Now let's take a look at this slide. This slide is the first scenario, that is when a tenant comes to court and files an answer. When tenant comes to court and files an answer, the court clerk will give the date of the first court hearing. And in Brooklyn, in my experience, that date would be usually scheduled sometime 4 to 6 months into the future. For example, if tenant filed an answer in January, the first court date would be set for April, maybe May, maybe even June. But when landlord and tenant come to court on that first court date, in Brooklyn, if the tenant does not have a lawyer, the judge may give a tenant another 45 days to find an attorney. So on this slide, I was trying to answer this question, when can landlord expect to see the judge for the first time after the case was started? And I did a little bit of math here. I took 14 days for 14-day notice. I added 1 week for service, then 4 weeks to wait till the court issues the index number, 1 week for service of petition and notice of petition, 10 days for tenant to come to court and file an answer. Then out of this range, 4 to 6 months, I took a more conservative side. I put 6 months till the first court hearing, and also I added 45 days that tenant may get to find an attorney. So together in total, it gave me approximately 10 months time. So to summarize, in Brooklyn, once again, those periods are Brooklyn specific. In Brooklyn, in Brooklyn, landlord can expect to see the judge for the first time approximately in 10 months after after the case was started, that is to say, after the service of the 14-day notice. I have to emphasize here, not all cases, by far, not all cases are resolved on the first court appearance. On the first day, you see the judge. Many cases take much longer, but the first appearance is maybe your first chance to have your case resolved. So I thought it would be it would make sense to take it as a benchmark, as an estimate. On this slide, I wanted to explain the alternative scenario. That is when the petition and notice of petition were served on the tenant, but tenant simply ignores petition and notice of petition and does nothing. And legally speaking, this is called a case of default. How does it happen? This is when all notices were served on the tenant. That is 5-day notice, 14-day, good cause eviction law notice. Then petition and notice of petition were served on the tenant. Then more than 10 days passes, but a tenant does not come to court and does not file an answer. So they say that tenant defaulted on this case. And in this situation, landlord has to come to court and file an application for default judgment and eviction warrant to have the tenant evicted from the apartment. And in my experience in Brooklyn, the whole process, starting from the beginning of the case, from the 14-day notice, up to the actual eviction of the tenant from the apartment, it takes approximately 7 to 10 months. So how I did the math, I took 14-day notice, another week for service. I took 4 weeks waiting for the index number, another week for service of petition, notice of petition, 10 days for tenant to file an answer, and then the application for default judgment itself in Brooklyn, in my experience, takes around 4 months, and another month for the execution of an eviction warrant, that is for the marshal to evict the tenant from the apartment. Altogether, in case of a default, when tenant defaults on the legal case, so from the beginning of the case, from the service of the 14-day notice till the tenant is actually evicted from the apartment, it takes in Brooklyn approximately 7 to 8 months.